Hello, everybody, and thank you for joining us for this webinar today. Brilliant to see so many people here. Today, we're looking at challenges under the Procurement Act, and of course, that's an area of procurement law that, if you're a non-contentious procurement lawyer like I am, you hope that you never have to deal with. But I suppose forewarned is forearmed when it comes to procurement challenges. So just by way of introduction, I'm Jenny Bursford-Jones. I'm a senior legal advisor and procurement specialist in the team here at Mills Reeve. And I'm really pleased to be here today with two of my procurement litigation colleagues, but I think of as proper lawyers. Claire Crawford, who is a partner who leads our contentious procurement team, and James Barry, who is a principal associate. He joined us last year from a role as a senior litigator for government legal departments, so lots of experience of defending public bodies. And both Claire and James have got a wide contentious procurement practice, acting for all sorts of public bodies, NHS, central government, higher education institutions, as well as on the other side of the fence too, for suppliers wishing to challenge decisions. So just a little bit of housekeeping before we get started. Welcome again if you've just joined us. We are going to be sending around a recording and the slides afterwards, so don't feel that you need to make lots of notes. If you've got any technical issues, just put a query in the Q&A box and Sarah will try to help you get connected. As always, we really welcome legal questions. Put those in the Q&A box as well. We can't deal with those during the webinar itself, but as always, we will send around a Q&A document dealing with as many of those as we can. And also at the end of the webinar, a very short feedback form will pop up, and if you can complete that, that would be really very much appreciated. Help us to design future sessions. So just before we get started, a little bit on the latest on the Procurement Act, on procurement reform. And I think the big news since we were last here in April, of course, is the announcement of the general election, which is on the 4th of July. And also that happens to be the date of our next 5 and 25 webinar on contract changes. And I'm sure Rishi didn't intend it to clash, but it couldn't be helped, so we'll forgive him. And I think there was a bit of noise at first around whether that election date would have an impact on the timetable for implementation, but Cabinet Office quickly confirms that the legislative matrix necessary for go live is now all finalised and all in place. So we're continuing to work to 28th of October as the date for commencement of the new regime. So there's the timeline there. We're in June now, and that's a really big month for the publication of the official guidance. The Cabinet Office are doing really well with this, but there are still a fair few guidance documents to go, particularly on some of the most interesting topics, such as the competitive flexible procedure, contract management. The score so far is published 16, not yet published 31, but you can have a look at that link there and keep up to date with all the latest guidance documents. And I think that's probably enough from me for now by way of introduction. So I'm going to hand over to Claire, who's going to give us a procurement litigator's view of the impact of the Act as she sees it. Thank you, Claire.
Thanks very much, Jenny, and good morning, everybody. So we'll start with our first question today, and I'm asked to consider what are the key takeaways around challenges and remedies under the Act. Thanks very much, Jenny. The next slide would be great. So I've set out here some headline points, and as a starting point, I think the broad headline on remedies, both prior to and after the contract has been entered into, is that they do remain substantially the same under the Act as they do under the procurement regulations we have currently. The process for challenging the outcome of a procurement or a breach of the statutory duty under the Act will still be through the courts. However, there are some interesting points of note which will have an impact on those remedies, and we'll talk about them a little bit more in some of the latter questions in this webinar today. But just to draw some of them out, we now have a new standstill period to observe, so there's a slight change there. There's also some slight changes around the automatic suspension and the period in which that will be imposed. We also now have a new prescribed test under the Act to lift the automatic suspension. And also the remedy of ineffectiveness that we had under the public contracts regulations has had a bit of a rebrand and is now known as set aside under the Act. So that's just a few points on those, which, as I say, we'll touch on later in more detail. But I also thought, as a headline point in relation to challenges, I think it's important to note that one of the big thematic changes that we see under the Act is the significant increase in transparency. And so the increased transparency will mean that there's far more information about the operation of procurement processes and the management of public contracts in the public domain. And so therefore there's likely to be greater scrutiny on authorities regarding their operation of procurement processes and management of contracts. And that could in turn give rise to an increase in claims and challenges brought pursuant to the Act. Suppliers will now have far more information available to them. And so the question remains as to what they will do with that information and whether that will essentially lead to an increase in claims and challenges where suppliers consider that an authority has acted unlawfully. And so this increase in transparency is really likely to hold those authorities to account, and that may well be through challenges. The last point that I just wanted to mention as well is on contract management. And now we have a completely different change in the scope of the procurement regime under the Act as we have had under the procurement regulations. And so the Act now extends beyond contract signature, which would have been covered by the public contract regulations. And we now have provisions under the Act which cover a wholesale management of public contracts to include performance all the way up to termination. So previously, in the main, the management of public contracts would probably, and any disputes arising out of that would probably have had their remedy founded in contract or causes of action in contract law. And that will still be the case. However, authorities will now need to consider their obligations under the Act when they exercise contract management and performance rights and obligations, and also when they're looking at termination. And so there could be scope for breach of provisions under the Act and for parties to seek remedies under the Act when they look at how authorities undertake those processes. So that's just the headline points on those for now, and then I'll pass back to Jenny, who'll deal with the next question.
Thank you, Claire. Yeah. So this question, when we were thinking about putting this webinar together, this question came out of something that we have observed really in terms of procurement litigation or potential procurement litigation. And of course, this is what sort of challenges might you see prior to the award stage. And of course, most procurement challenges arise after the point of award of the contract, so during or following the standstill period. But of course, that's not the only type of procurement challenge you can see. And sometimes the issue that gives rise to the challenge happens earlier in the process. So perhaps during the selection stage or during the evaluation, for example. And one of the issues for suppliers, of course, is that the limitation period for procurement claims is really short. So it's only 30 days from date of knowledge of the breach. And sometimes we see supplier clients come to us during the standstill period, for example, with a potential complaint about something that happened earlier in the process, but they find that they're already actually out of time by that point. But I think we have seen suppliers becoming more aware of the need to preserve their position, not to sit on their hands in terms of challenging earlier on, and at least raising a complaint to try to get the procurement rewound or restarted. And there are a few features of the Act which we think may have the potential to make these kind of earlier on in the process challenges more common. And one of the things the Act does is to increase flexibility around setting conditions of participation. That's the new world name for what we currently know as selection criteria. Of course, it's always going to be necessary, even under the Act, as it is now, to apply mandatory discretionary exclusion criteria to check whether a supplier is excluded or excludable. But I think overall there looks to be a bit more leeway in the Act around setting conditions of participation subject to broad parameters. We're not quite clear as yet how the CCSSQ is going to operate under the Act, but Section 22 of the Act does clearly contemplate that conditions of participation are things that an authority might choose to set where it's proportionate to do so, but equally it might choose not to set them. We do seem to be moving into a world which is a bit less prescriptive than the CCSSQ. And one thought we had in the team here was that this flexibility may be accompanied by an increasing possibility of authorities using conditions of participation in a way that don't quite meet those requirements as set out in Section 22. So that is to be a proportionate means of ensuring that suppliers have the legal and financial capacity, technical ability to actually perform the contract. And then, of course, if those conditions of participation are not compliant with Section 22, this could well prompt suppliers to raise one of those early in the process type challenges. The other area we thought of in this regard was around exclusion. And of course, as I said earlier, exclusion is not new. It's already possible for suppliers to be excluded under the PCRs. But of course, under the Act, the consequences of exclusion are a referral by the authority to the debarment service. And of course, that's not to say that all excluded suppliers will definitely end up being debarred. Far from it, I think. But the consequences of exclusion run much wider for suppliers under the Act than at present. And I think that also means we may well see suppliers being much more robust about challenging an exclusion wherever they possibly can. Presumably they'll be arguing that the authority has not been reasonable in refusing to accept their representations as to self-cleaning, for example. So again, that's another area where we might see these sort of early type challenges. There's also express sections in the Act now around the right, subject to safeguards, to change the procurement process as you go along, or indeed to modify award criteria during a live procurement. And of course, where a supplier feels prejudiced by those sorts of changes, that is a challenge that they will need to get on and raise within 30 days, rather than waiting until standstill or award. And then finally, as Claire touched on earlier, one of the sort of standout new features of the Act is this extensive new transparency regime. So it's giving authorities a statutory duty to publish a whole range of notices to the new central digital platform during the whole life cycle of contracts. So from pipeline planning through to advertisement, contract management, as Claire was saying. So in theory, a claim based on breach of the obligation to publish a notice could well come early on in a procurement, depending on which notice it is. And one of the things that authorities have asked us is, what happens if we get the notices wrong? What happens if we forget to publish one? Can we be challenged? And of course, these new obligations are so new and so wide-ranging. It seems certain that even the most diligent and hard-working authority might fall short on one or two notices. So we have got Section 100, which makes it clear that suppliers only have a right to challenge if the breach, so the failure to publish the notice, means that a supplier will suffer or will risk suffering a loss. And in our view, that might sometimes be difficult for suppliers to establish. So if an authority doesn't get its pipeline notice quite right, would a supplier be able to argue that that leads to it to risk suffering a loss? But I think some notices are more significant than others, particularly those which act as a kind of trigger to start a standstill period, for example, so the contract award notice, contract change notice. And in relation to those, it would be much easier for a supplier to argue that the failure to trigger has led it to miss out and be disadvantaged. And I think that is a very good point to hand back to Claire, who's actually going to have a look at that standstill and award phase. Thanks, Claire.
Thanks, Jenny. So the next question for me is, what is the effect of the Act on the outcome of the procurement? So this is an important stage for challenges, as the outcome of the procurement process remains the stage at which we see the most legal challenges made under the public contract regulations. And I think we can expect that to remain the position under the Act as well. And so it therefore becomes important for us to assess what changes to the outcome of the procurement process there are under the Act, as this will be very important for both suppliers and authorities in assessing whether to bring a challenge and also how to deal with a challenge if one is in fact brought. So looking at that outcome process, the first stage, which looks a little bit different, is the use of the assessment summary. So this is what we currently would know as the standstill letter or the notice of award. It's the document in which authorities will communicate the outcome of the procurement and provide debrief information to bidders on the evaluation of their tenders. We've talked about the assessment summary in quite a lot of detail in some of our previous 5 and 25 webinars, which are all available on our procurement portal. However, we can expect to see the information provided in those to look broadly similar to what we see at the moment by way of debrief information, but it probably will look and will be set out quite differently. There were some aspects in the draft secondary legislation, the Procurement Regulations 2024, which haven't actually been taken forward in terms of in additional information that we would have seen in the assessment summary. But one thing that has been taken forward, which is of interest, is that we no longer have reference to that characteristics and advantages, relative advantages assessment, which was always quite tricky for authorities because it meant it had to sort of undertake what was quite a difficult comparative exercise between the scores given to the provider to whom they were sending their debrief information and the winning bidder. That always became very contentious between parties. And now, with the way in which assessment summaries will need to be drafted pursuant to the regulations, that might take some of that contention away. So that's an interesting point of note on those. Following provision of the assessment summary, authorities must now publish a contract notice, which is the notice that triggers the standstill period. So it's not the contract notice that we have at the moment under the PCR, it's a different notice with the same name, which is something there to trip us all up under the Act. But essentially that commences what is now a new standstill period, which is 8 working days as opposed to the 10 calendar date period under the public contracts regulations. Also an interesting point of note there in your contract notice, authorities are obliged, if the contract value is over £5 million, to also name the unsuccessful suppliers in that contract notice. So that's something to look out for as well in the operation of that. Following the standstill period, if the authority hasn't received a claim form or notice of a claim form during that period, it can proceed to enter into the contract, as it can now under the regulations. If, however, a claim form is received during the standstill period, the automatic suspension will apply and the authority will be prevented from proceeding to enter into the contract until such time as one of the criteria for that automatic suspension to be lifted applies. There are some changes under the Act to the operation of the automatic suspension. Presently, under the public contracts regulations, the automatic suspension is imposed upon the issue of a claim form at any time prior to contract signature. However, now, under the Act, the automatic suspension will only apply where a claim form is issued during the standstill period. And so that does represent a narrowing of the effect of the automatic suspension now under the Act. There could be various different ramifications arising out of that, and this sort of does throw up various different questions. We've put a few there in terms of, will there now be less hurry to enter into contracts and sign up? Do authorities need to be so concerned about that if the standstill period has expired? Will we see more claims where we seek a remedy of now set aside, previously ineffectiveness, because of the narrowing of that, the scope of that sort of injunctive effect? So it will be interesting to see how that works going forward. In addition to that point on the automatic suspension, and as I mentioned in the question earlier, we now have a new prescribed test for lifting the automatic suspension. That test broadly follows the same principles that are applied at the moment under the public contracts regulations. The courts have applied the test that's applied to all applications for injunctive relief, which is known as the American cyanamide test, and has developed various aspects in case law applying that test in these specific circumstances in a procurement context. So the prescribed test we now have under the Act very much broadly follows that prescribed test that has been developed over case law. However, as with many aspects of the Act, there are some changes in the language used, and where this occurs, there's always scope for different interpretations. And so we will have to watch this space as to whether there are any material differences to how we approach these applications in the future. Just on a final point of note as well, I think it is also interesting as well to note that we now can observe a standstill period, and the automatic suspension will apply also in respect of modifications to contracts. So following a contract change notice being issued regarding a modification to a contract, the authority can observe a voluntary standstill period. And so in that respect, if a claim form is issued taking issue with the proposed modification, then the automatic suspension will apply if that claim form is issued during the relevant standstill period, and that will prevent the authority from proceeding to enter into its contract change. So that's also an interesting point of note and development under the Act. Back over to you, Jenny.
Thanks, Claire. That's a really interesting point, isn't it, about that widening of that automatic suspension to contract changes. I was just going to say a little bit about the role of the procurement review unit, because as Claire said at the beginning, it's still the case that the only way the authority can be forced to do something, or the award of the contract or the contract change suspended, remains via the court. But we have now got the procurement review unit, which is a significant body, and it's going to have a much wider reach than the current procurement review service, or which used to be called the mystery shopper service. I think you can't really talk about the procurement review unit without also acknowledging the role of the central digital platform in the background. And the reason for that is that the platform is going to be providing so much data with which the PRU will work. So there's going to be the finder tender service, the supplier information service, and particularly those unique identifiers. So for each authority, each supplier, each procurement, each contract, it will be possible to sort of get access to all sorts of information, and developing a really sort of big picture of information over time. So that is the sort of bedrock upon which the PRU is going to be operating. There are three parts really to the procurement review unit, as set out on the screen there. The first is the procurement compliance service. So this is the part of the PRU which is going to be looking at sort of systemic and institutional issues. And as I understand it, they're going to be looking at the data from the central digital platform, but also receiving referrals. And its job is going to be identifying and helping to rectify areas where the Act isn't working. And there is quite a formalised process. So they would be investigating, making recommendations in reports. Those they discuss with an expert panel, and then they actually refer them to a minister who can reject or approve it, and then finally give approval of recommendations. So there is ministerial input into the work of the Procurement Compliance Service, which is not something we've seen before. The Public Procurement Review Service is a sort of beefed up version of what we currently have. So this is for suppliers, and it's where suppliers can make specific complaints about specific procurements. They won't be able to get those court remedies, of course, but they will be able to make those complaints. With a slightly expanded role also into contract management, reflecting what Claire said at the beginning about how the reach of procurement has extended. It also seems to have a bit of a role as a triage for other services, and passing data to the Procurement Compliance Service. And then just a word on the debarment service. So they are considering whether a supplier is excluded or excludable, and if so, if that supplier should go onto the debarment list. And they are thinking that they will investigate most exclusions, although that's not to say that all of those, or indeed most of them, will actually be debarred. So just a bit of a background in terms of the PRU and what it's going to be doing is sort of a bit beefed up really compared to what we currently have. But I will stop talking on that and give time for James to cover what perhaps is a more interesting topic, and that is the effect of the Act on contract claims. Thanks, James.
Thank you, Jenny. Hello, everyone. This is our last question today, and we're going to be looking at how might the changes to the law affect the contract claims. Now, I think tomes will be written on this in due course, and this is quite difficult to cover in just 5 minutes. But what we want to do here is really give you a flavour of the kinds of issues that may occur. And in order to do that, we need to think about how the law is going to change the relationship between suppliers and authorities after the contracts have been signed. Now, of course, under the current law, under the current regulations, once the contract is signed, that's really the end of the procurement process. But of course, under the Act, as I think has already been said, the Act will govern and deal with how those contracts are managed going forwards. And that will, of course, have an impact on the contractual relationship between the parties. Now, the Act does this in several ways, and it's primarily through the use of notices which are issued by authorities, and authorities are required to do this, to issue notices which are published so that the public can see them, anybody can see them through the life of the contract, upon the occurrence of several different circumstances that may or may not occur. Now, we've got them on the slide there. We have payment compliance notices, which are publications about monies which are paid or made or owed under the contract during a 6-month reporting cycle. There are contract performance notices, which are the publication in some contracts above 5 million of yearly performance, where they're rated against a KPI, and whether the performance of the supplier is inadequate or all the way through to good. There's also performance where the supplier is performing to the authority's satisfaction, and we'll come back to that in a moment. There are contract change notices, which I think have already been touched upon, where if there is a substantial modification to the contract, there will be a requirement to publish that and provide that to the public. And also upon termination at the end of the life of the contract, where there'll be publication within 30 days of a public contract having been terminated, an inclusion of the reason why that occurred. So quite different from the current circumstances. And the effect of these notices is potentially significant for contract disputes, of course. One thing that might occur is that authorities, because of the increased transparency, will feel under greater pressure to deal with these issues, and it will perhaps lead to an increased tension between authorities and suppliers, meaning that a tougher line is taken by authorities who might be anxious to demonstrate that they're getting value for money for the taxpayer. We can look at Section 71(5) particularly, and we've set out on the slide here, and you can look at this later as to what the Act says on these points. But what we're dealing with here is performance notices. And what we're going to focus in, to give you a flavour, is where the authority is not satisfied with the supplier performance of the contract, and where the supplier has been given the opportunity to improve, the supplier has failed to do so. This kicks in, well, we'll look now if we go to the next slide. Well, what does it mean not performing to an authority's satisfaction? Well, to what standard is the performance held to? The e-learning that's been published by the government gives a suggestion as to what this might be, but at the moment this is unclear, and there may be a tension between the authority and between the supplier as to precisely what this is to mean, unless it's otherwise specified within a contract term. It could be dealt with within a contract term, but of course it may not, and then there will be a question for the courts and for suppliers and authorities as to what that means. And if we go to the next slide. And then we go finally to what is a proper opportunity to remedy. So it may be that there will be a contractual mechanism to allow a supplier to remedy the fault or the problem. But of course, if that hasn't been provided for in the contract and there hasn't been provision for that, does that give rise to a separate obligation on the authority that will be implied into the contract to give an opportunity to remedy or to fix the problem? Or will the court fall back on the terms of the contract itself and say, well, we'll look at the common law and we'll look at what the contract says in order to determine this issue? So really the takeaway here is saying there's lots of questions that have got to be answered and will be dealt with in due course by the courts. There's a great deal of uncertainty as to how the interaction between what the Act now says and what the common law says and what the contracts themselves say and how those different factors will interact with one another will cause perhaps a great deal of uncertainty, which will have to be resolved in the courts in due course.
Thank you, James.
Okay.
That's really helpful survey of some of the challenging questions that I think we've got ahead, or particularly you as litigators have got ahead. So yeah, I think it's time for us to finish. So many thanks to you all for joining us. When the webinar ends, there should be a feedback form at the end. So if you could complete that, that would be very much appreciated. And as I said earlier, the recording and the slides and the Q&A document will be circulated as soon as we can after the webinar. Our next one is on contract changes. That's on the 4th of July. So you can cast your vote in the election and then pop back home or pop into the office to join us. Contract changes, that's another big topic for sure. And then finally, just a very big thank you from Claire, from James and from me for joining us. Hope you found it helpful and have a great day today. Thanks very much.